Battling bullshit by stating facts. Oh God, the triggering you will do. Here we go. Reading the actual definitions people bring up, but I'm going to bring up the first one. The 10 maxims of commercial law is an unenforceable list invented before September 5th, 1996 by sovereign citizen, freemen on the land. It's not the law or rule. And it invokes things like deciding certain parts of the Bible are actually the law of the land in the United States when that's not true. Again, this is of, by, and for the people, at least in principle. And so to get around the fact that literally everybody in the country has a special interest group attitude towards you wanting to get away with some bullshit in court and saying no to you because we just outnumber you and we actually have the rule of law on our side, your reaction is to invoke the Pope. So I'm going to bring up useful information, explanations, because I'm just going to invoke certain words. And then you got to go look them up. Okay, you just came to the YouTube video that explains all the shit. The 10 maxims of commercial law is an invented bullshit list that has no merit and is non-enforceable. And people will squeal about it at the top of their lungs. And if you start invoking it, it's like invoking the Third Reich statements. You get ignored. In jurisdictions that chose to follow the English Chancery's Court of Common Law system, equity is the body of law which is now administered concurrently with common law as a distinct body of law, or not, depending on the fusion versus non-fusion rule and argument. The framers of the Constitution granted the federal courts jurisdiction over both common law and suits in equity, based on general principles of fairness in the case of equity, in situations where a rigid application of common law would have brought injustice. This is a kind of off-the-cuff, we've decided not to do these things because it does have the effect of causing tyranny. So equity law does exist. And it's named that way to cause equity to be the rule. It is not determined to be done by the King of England. Borrowing rules and ideas from another country doesn't give them power over you using them. Just because gravity was understood and discovered in another country doesn't mean they have the right to turn it on and off like a light switch. The framers of the Constitution made some decisions on this. An important distinction between law and equity is the remedies each offers. People then get triggered on these words. I don't care. A court of law can award monetary damages and make also decisions of sorts, such as putting you in prison and that sort of thing. If there is no adequate remedy in law, as in monetary damages, or insufficient to remedy for the injury in question, or inappropriate or would be misapplied since it's not about money, it's about something else, then equity enters injunctions or decrees directing someone's actions. The rule with equity law is that you can use it to force someone to undo the damage they've done or make it right. If someone steals my cow, they don't just get the right to buy it from me by giving me the monetary value. I can demand that specific cow back, if possible. And this can be the preferential method because it has an interesting effect. It punishes the thief. And then they have to pay court costs, or maybe pay financial damages, or if in the case of real theft, prison time. Your payment for your misdeed may outweigh the value of the damages to punish you. So it's not equitable all of the time. If someone attempts to murder me, and they do it as part of some specific pattern of behavior or thought, they may be punished more than they would for a simple murder, even though I haven't been killed, because the act that they did and the reasoning behind it are taken into account. 1839, the Supreme Court held that federal courts sitting in equity were bound to apply state laws, as less emphasis was placed on the historical or institutional origin of substantive legal rules. So, no, the King and Queen of England don't get to determine these things, nor does their legacy ring on in our independent country. The question of whether a case should be determined by a jury also depends largely on the type of relief the plaintiff requests. The defendant sometimes doesn't have a right to a jury trial if it isn't something that would critically endanger them for life, liberty, pursuit of happiness, that sort of thing. If it's just a matter of giving back the car you stole from me, you don't necessarily have a right to a jury trial if there's no criminal charges or punishments beyond an equitable solution. Give me back my damn car. And also, even in equity, you can have more punishment than you deserve at that point. Prior to independence, vice admiralty courts were created in the colonies by commissions from England's High Court of Admiralty. Nautical issues and private maritime disputes were dealt with in these cases. Again, emphasis added, we're not part of the Court of England. After 1776 or whenever, states established admiralty courts as well, since the Constitution used the term admiralty and maritime jurisdiction without defining them. But in 1789, approximately, Judiciary Acts stated that the district courts would have jurisdiction over all seizures under the revenue, navigation, and trade laws of the United States, not independently. They inherited federal control. Maritime law is only so far operative as law in any country as it is adopted by the laws and usages of the country. The laws in your country determine whether or not you allow maritime law. Maritime law is not universal, nor is common law, nor is equity law. They're used as a building block, a starting point, but they're not absolute. Demanding that someone apply equity law when you're guilty of shooting at me may actually make sense and would be a very bad thing for you to do. You'd want it just to be paying for the damaged leg. Judicial power of the United States shall extend to all cases of admiralty and maritime jurisdiction. Maritime and admiralty jurisdiction is then trumped by United States federal law. These are decisions that were made. You don't like them? Go change them. Until you change them, they apply. The jurisdiction of admiralty law was then limited to only some maritime commerce, such as when two vessels collided or when a shipmaster or shipman was injured on a vessel in service in navigable waters of the United States and in some cases outside. If you walk into a courtroom and say it's an admiralty court when it's not, because it's not just where the subject matter is outside of the scope and has nothing to do with ships at sea or on rivers, you are lying to the court about what it is. This does not have to be respected. And the first thing you'll say here is, this is not an admiralty court. It's held under the laws of the U.S. government, and I don't give a damn if you like it. You're going to be held under them against your will and adversarially. And then if you continue arguing, your argument has no merit. You are forbidden from defending yourself in court. You will have a lawyer do it. You pass the bar or play limbo and try to crawl under it. The framers of the Constitution contemplated that the law should forever remain alterable and not fixed. If you invoke a law that's been outdated or invalidated, no one has to respect you. You're not allowed to implement a rule about having to pass the duchy on the left-hand side or whatever when we're flying planes and can fly anywhere we want to. Article such and such, section such and such of the U.S. Constitution granted original jurisdiction to the U.S. federal courts over admiralty and maritime matters, but these may be brought either in federal or state courts as well. But they do have first bid at this. Next, the Erie Doctrine gets brought up. It requires that federal courts hearing state actions must apply substantive state law because it imports the law from the states for the Erie Doctrine. The reverse of this requires state courts that determine they are dealing with admiralty or maritime cases must then decide to use or not United States federal admiralty law, because the federal law does have the right to overrule state laws in some cases. It depends. The state courts are allowed to apply state procedural rules, and you are not allowed to walk in and say, I want you to use maritime rules on a state level because of that. The law of the sea is a body of public international law dealing with navigational rights, mineral rights, jurisdiction over coastal waters, and the maritime relationships between nations. And you attempting to invoke this because you got caught speeding or parking badly just means you shouldn't be piloting a ship, number one. Number two, your argument has no merit. 1942 Uniform Commercial Code was the product of private organizations. It's not in of itself a law. It was a set of suggestions brought together. Only a recommendation of laws that should be adopted in the states. It became a set of laws that ended up uniformly adopted as the state laws because all the states agreed that they should. Some states have made structural modifications to conform to local customs, so state law overrules UCC. The only punishment for this is some states don't allow you to do certain things between each other because they have different laws. For instance, in California, if I walk across the border, which we have one with them, and I walk in with a gun that I'm legally permitted to have, they're legally permitted to get away with taking it from me and maybe even charging me with a crime, even though it's not a crime in the state of Oregon. Don't like it either. It's not uniform, but oddly enough, that's an example of UCC ruling type behavior. States get to have their own traditional rules. These rules govern all commercial transactions between states, but are not imposed on them, as they are not federal or national law, nor was an external to the USA or brought in from merry old England or the Queen or reptilians because it was done in 1942. The ALI and NCC-USL have established a permanent editorial board for the code, for UCC code. Their works do not have the force of law and they do not have authority. However, people usually listen to them and it's used for figuring out how to make new laws as a guideline. Portions of the UCC have been highly influential outside of the United States as a building block in order to build international or just simply intrastate or inter-country commerce. Saving file. That's my entire point. Jurisdiction cannot be achieved if the court, the four corners rule of law is not, hold it. You just said a grammatically fucked up sentence and you misspelled the word for. I'm supposed to listen to you. Let's try this again. Without, this is a nested loop problem. You've managed to crash the compiler. I'm sorry, B-sod. Cornflower blue. That's your entire point. A jurisdiction cannot be achieved if the court is not grammatically valid. Bullshit. You don't know what you're talking about. And you guys walk into a room using made-up grammar to people who are using normal human grammar that we use. We actually have grammar already. And they tell you, you're not allowed to correct our grammar. You're a grammar Nazi. Fuck you. Next. Once again, grammar is the key. Anyone who answers to being a person or individual or U.S. citizen, a human being, is entered a contract with violation of the non-living entity. Me saying I'm a living human being in the flesh, I'm an individual person, and I happen to be a citizen of the United States, means I'm entering a contract with a non-living entity because you've decided magic words and phrases work just as good as Ouija boards. Ouija boards are a toy that was invented by, I think, Whammo or Hasbro. They never existed before that year anywhere on Earth for any kind of Ouija boarding stuff. I'm making fun of you. Next, in case you're too stupid to get it. Therefore, surrendering your land-born sovereignty of you, admitting to being a person in your driver's license. So you misuse the word person, human being, and individual because they're used a lot by liberals, individuality in the United States. You don't like the fact that you can't win a court case because you're refusing to learn the law. Trust me, bro, grammar's everything, but you failed at it and spelling and logic. Basic may be too hard. Learn binary. Thanks for watching. Have a good day. Good luck with that. I'll leave your comments below wherever I can find them. Bye.